is amendments to our Syracuse Property Conservation Code, but specifically sections that regulate administration and enforcement of the business certificate of use. So it includes changes or updates to definitions, when it's required, kind of clarifying different administrative steps, the inspection steps, the application process, the procedures for a hearing. It really just bolsters and updates our ordinance so we're properly giving due process, but it also allows us to apply a more uniform enforcement effort citywide against establishments that require this.
Okay, what, there's a few things, I don't know if anybody else looked through this as far as, I think a couple things stood out for me. I know this isn't used a lot, but where you grant a certificate of use in, predicated on them finishing some things, you call it like a certificate of use in lieu of finishing some of the requirements and the effort to like start the business going.
Yeah, so certain establishments require this business certificate, bars, restaurants, gas stations, corner food stores, et cetera. It's a 2-year license. It includes an inspection from Syracuse Fire Department, Fire Prevention Bureau, and a codes inspector, but other things are checked too. Taxes, water, things like that, as part of the process to make sure that both the building owner and the proprietor are, following all city codes, laws, rules, regulations to operate a good business.
Well, I was more or less referring to like flexibility on the part of your administration, like to do conditional certificates of use. Because I notice in here that right now to respond, there's like a 90-day gap. Is that it? They got 90 days? That you have to review everything, but you got 90 days in order to, and usually probably goes right to 90 days, right? It probably puts an onerous burden on some of the businesses, though.
Right. I mean, part of the issue here is there are a number of businesses that just haven't applied to us.
Right.
So we're trying to just, educate them that this is a requirement and here's why. But yeah, we have had cases where we've issued conditional licenses. And listen, the intent of this isn't just to go close down everybody that, isn't working with us. But we need people to understand that this is a law in the books. It's always been a requirement. CFU's been around a long time. It's recently, become an enhancement tool that we've used against bad operators, I'll say. For things like suspension or closing them temporarily or even permanently in some cases. We're seeing a lot of bad actors out there, that are doing a lot of dangerous things, in our community that hurt neighborhoods, they hurt youth, whether it's, illegal sales of cannabis or tobacco or spike or alcohol. All sorts of things. And this is just another enhancement of our tools to help, regulate those things in our neighborhoods.
So the ones that aren't applying to us, they're just opening them up? Just renting
Yeah,
someplace?
or just not renewing them, like they're required every couple of years. And, I don't have the list in front of me, but some of these are gonna be more,
You send them notice when it's
We-
coming up
We
time for
we
them to
do,
renew?
and we just sent out a whole batch letter of all the places that are currently not compliant, kind of giving them a heads up, like, hey, like, this is overdue, you need to submit this, here's how to apply. So we have done that.
How much of that is corner store?
I don't know exactly the percentages. There's a few of them, but it's also
Yeah.
quite a few restaurants, bars that just haven't traditionally applied for the certificate of use.
If there's a change in ownership, they have to do a new conditional. certificate of use.
So, yeah, one of the things we changes was when a new certificate of use is required, and we clarified it in the proposed amendments that any transfer of the ownership interest of the business, whether that be a transfer of the LLC or if somebody individually bought the business, the new business owner would have to come in and reapply for a new business certificate of use.
Does that include, sorry, this is loud. Does that include also, if the name of the business stayed the same, but the owner was new?
Yes, so even if they retain the name of the business, it's the change in ownership that the city would be interested in making sure that they could correctly identify all involved parties in case we have problems down the line, so we know how to contact the appropriate people.
Didn't they report that before the 2-year term?
Sorry, repeat that? Sorry, I didn't hear you.
I mean, if somebody changes ownership, shouldn't they be reporting that even before the 2-year, they should?
Ideally, yes, that is required in our ordinances. Unfortunately, either awareness or people just don't report that to the city consistently, so we're not always aware of change in ownership interests.
Jake, in the definition, we're going to go into food market instead of a corner store.
Yeah.
So the definition of food market is going to be a food market. It's not going to be a place where we're selling alcohol, we're not selling beer, we're not selling tobacco. Is that going to be, are we going to enforce it, that these will be excluded? It's going to be a food market, nothing more, but a food market.
So I think the
thought
new
it was
term is
changing from
neighborhood
food
market
market.
that we've
Yeah.
replaced, and I think, I'm looking at the definition, it says fresh foods or drinks. It's kind of we've kind of used the prior definition of food store as the base of that, and we're trying to make the new definition more closely aligned with convenience stores and corner stores with the amendment. As far as places like a smoke shop that sell only tobacco products, that would be classified as a smoking establishment. But I think like a convenience store that would sell liquor or beer for off-site consumption would fall into the definition of neighborhood market.
Because I had someone came to me recently, wants to open a store on Grand Boulevard, it was the old Cornhouse Restaurant, and I explained to him, I want fresh food, I want no alcohol, no beer, no tobacco products, and I'm emphasizing that. We got our share of smoke shops, and we need fresh food markets. And that's what I want, that we're going to force it. The definition of a food market is food, nothing more.
So part of what these definition changes are, why we're doing them, is to align with the land use regulations in the zoning code. So to Rob's point, I'll be honest with you, a lot of this is really so people can't call their corner store a grocery store and get around certain requirements. That's why we had to change this definition. So a neighborhood market, I totally get your point, and I agree with you, but a neighborhood market could include sales of, alcohol for
And I
off-site
think
consumption.
as I look at it more closely, the last sentence does say that a neighborhood market is distinguished from a drugstore in that it does not sell prescription drugs, but may sell tobacco products and alcohol beverages if licensed.
Well, this is how we're going to get the bad apples out of there.
Yeah, it's part of it. So what we've been seeing in the last year are people that were opening up corner food stores and claiming they were grocery stores, and in the zoning code, there was a different path forward. And I'm like, everybody, I think, can distinguish the difference between a corner food store and a grocery store. We need real grocery stores. These are not real grocery stores. These are not Wegmans, Price Chopper, Tops, Aldi's. These are exactly what we're defining. They're neighborhood markets as defined in selling those products.
We have some real ones
Yeah,
along
we know,
markets.
there's a delineation, your local 7-Eleven, not to pick on, is not the bad actor, right? They sell tobacco and alcohol legally, which both are legal, but they're not doing what these corners are doing, just where they're popping up and selling Spike over the counter. We hope not, but for the most part, a corner grocery store is much different than a pop-up.
Yeah, and I want to be clear, these changes I don't think really impact the good actors. They don't really change much for them. Those people will continue to comply, get their licenses, maintain their tobacco license, maintain their C of U, get their inspections with the fire department and with code enforcement, address any issues that may pop up in between. This is really to help, bolster our efforts against some of the bad actors, unfortunately.
Jake, why don't you go over procedurally exactly, like, okay, I want to open up a store or a restaurant or something. I fill out a certificate of use. Now, where does that go from there?
Well, so there's actually steps before then. So the first thing we need to do is make sure that they have proper land use to be in the area that they're in. So whether that means they're new or taking over a business or changing the business or just opening up an entirely new business, they have to meet the zoning code and go through the land use process first to get approval for whatever it is they want. Let's say a restaurant or a bar. Okay, if that's good, then the next step is a building permit. So you get your land use approval first, then you get your permitting to construct and or change, make sure there's proper safety things like egress, sprinkler protections, whatever the case may be. The last step are your operating kind of licenses, whether that's a tobacco license, a C of U, a liquor license if you're selling alcohol, an entertainment license if you've got music, dancing, etc. So it kind of goes in that order. So the C of U is really the last part of that. And then once you have one, if you stay open every 2 years, you have to renew. So what that includes is notice from our department, and then the owner has to schedule an inspection and clear all those kind of background checks that I talked about for water, taxes. Police does a check as well. And if all that's clear, you get your certificate, and you're good for 2 more years.
Yes, but who sort of guides these folks, especially new folks? I'm thinking like
Yeah.
an immigrant population or somebody like that. Who
Yeah,
guides these folks through that?
So if you have to start from the very beginning, it really starts with our permit office, and then it kind of hands them off to the zoning team, and then we work with the permit team to get them what they need, and then from there, the same code inspector who's doing the permit inspection, we just have to get the application and payment for the C of U, and then they work with the proprietor.
Usually hosts a meeting with everybody.
Yeah,
so that
we do
everybody
like intake
understands.
meetings, we bring them in.
Pre-development
We
meetings?
we
Yes.
have brought in interpreters for certain situations when there's a language barrier, trying to make sure that this, these regulations are clear and that they're understood and that people understand like what it is, why they need it.
So there'll be involved planning commission too, right? Correct?
Potentially, if the land use calls for a major site plan or a special use permit, the special use permit would then work its way before the council as well. So it depends on what the land use is or if it's already established or not, if that makes sense.
So Jake, what happens if they bypass? So let's say if I call you tomorrow and tell you that Fayette and Westmoreland, all of a sudden, a pop-up store opened up again, what do you do? What's the mechanism to actually get them shut down?
We would provide them a notice that they're operating unlawfully or illegally, give them some due process to have a hearing and to apply for and obtain, but in a lot of cases, they won't be able to in a short amount of time. So in many cases, they'll have to close until they can get that. And we've seen that even recently. We've had people before the council for special use permits that are, they've had to remain closed until they get through that process. Does that answer the question?
But then there was a time where they remained open without any, because we had to go through a legal process. Like last year, 1414 Grant Boulevard, I had a discussion with you, I had a discussion with Joe Barry, had a discussion with the administration, and I was told, well, counselor, we have to go through this legal process, but they remain open. Yes, counselor, but we have to go through this legal process to 3 months to get it closed. I think there should be something in our laws that if you open up a legal business, you get shut down immediately. I don't think we should have to go through this legal process for 3 months. And I said this last year, and I said it to Corporation Council, and I think that's something as a council we should consider.
Sure.
To that question briefly, for businesses that are operating without a certificate of use, we've created a new provision in the code that, that addresses our administrative procedure for that. While we still feel we need to give them due process, an opportunity to be heard, we have streamlined the procedure so that we are automatically scheduling an administrative hearing, giving them that chance for a hearing. We have shortened the time periods in which the division is required to issue a hearing determination on that hearing, and then ultimately a final order. It will require more work for the division, but the law department intends to be there at those administrative hearings to make sure that they're going smoothly and that we're getting to the final final orders of whether the business can remain open or closed as quickly as we can, while also preserving businesses and individuals' due process rights on the businesses that are operating.
How do we get like a judge to, if a judge shut it down? We have to wait for a legal process or it goes to
So
court?
if we wanted to get a judge involved, we would have to bring a legal proceeding,
Okay.
probably in Supreme Court. And That's another way to do it, but it would take probably quite a bit longer than how we could do it administratively. When we get judges involved, the defendants have a chance to answer. There's usually going to be several court appearances before we get an ultimate decision. So that's going to take, I'd say, if we're fortunate, several months before we get to the end of the line. And then it's probably just going to be an injunction preventing them from doing something illegal like selling cannabis or tobacco without a license.
Say, going back to the possibility of someone purchasing a property or a business and unknowingly not filing for their own C of O or AU, whatever.
Yep.
Because you said that you're no longer going to be doing temporary, what is it, C of Os?
C of use.
C of Us.
Yep.
Conditional.
Yeah.
Conditional.
Oh, conditional,
Yep.
yes. So if someone was in that phase where they purchased and they just was trying to pick up where the previous owner left off, kind of turnkey situation, would that not constitute a conditional certificate until they are granted their own?
So I think when we were looking at the code as it was, the conditional certificate of use that were uses, those provisions that were in the existing code essentially required the same showing as our traditional certificate of uses, and the division didn't frequently issue those. So the purpose in eliminating those was to just clear out something we don't use. As far as, I guess, when we're talking about businesses that don't have issues, they aren't doing unlawful things. We don't have an issue with their licenses or anything like that. I think we could talk about issuing kind of regulations or administrative guidelines from the division about how to handle those situations. Because I believe, as Jake said, the goal here isn't to close everybody down. We just want to make sure we have all the businesses that should be in the program, and making sure that everybody has the appropriate licenses.
Well, I just want to kind of,
Yeah.
let me just phrase it towards like a specific business.
Sure.
One of the businesses on East Fayette Street, the guy purchased from someone else, and he was shut down because he thought that everything was in place, I guess. So how would that affect him? He wouldn't have been able to stay open, or did he have code violations? It was like a store.
Yeah, without the specific address, I'm not
So,
familiar with the
yeah, and a
exact
lot of this
property.
can really go above just the licensing requirement. There's specific land use needs too, and a lot of establishments require special use permits. So some of that can impact an establishment. We try to educate people to do their, due diligence before closing and buying something. If we tell them their attorneys, their real estate people, whatever the case may be, call our office, make sure you have proper zoning, like check the permits, check the certificates, unfortunately, it does happen sometimes where, people get themselves into a bit of a jackpot of a situation where, they need to work through some things. And we try to do our best to help people through that process too. And to Rob's point, those aren't the people that we're trying to harm, but we do need to try to make sure that we're being uniform in how we're treating everybody with this. And that's part of what we're trying to do here, is be consistent, because I can't treat, one person different than how I treat another. And that's what we're trying to round this into. And it does become complex. Every situation is a little bit different. And we can appreciate scenarios like that. But what we're trying to do is just apply the laws that we have and the procedures that we have uniformly across the city.
We have a mechanism to hold the building owner responsible if they're renting it to someone without?
You do now.
You do, right here it
So
says that the building owner has to.
So we have, in the current amendment, we have changed the application and the ordinances to require the building owner to sign the application. And the goal of that is to make sure that the building owner is representing to the city that they are aware of the business that is going in, and that they're going to be responsible if there's unlawful activity. We have the ability to cite property owners under a different provision of code that is not in this amendments, and that would probably be the mechanism for letting the property owner know that we're having problems. We would cite them under that and identify the issues for them.
When filling out for a certificate of usage, how long does it typically take from the time you apply until the time someone responds to them for your application?
Meaning how long it takes a business proprietor to apply to us
No,
afterwards?
once we apply, say I
Once you apply,
applied, right?
yep.
And I gave you the paperwork. What would be, how long will it take before the next step, before you were to call or someone from your office to say what's next?
Yeah, so the point person for all this is the licensing coordinator out of the central permit office. So they're the one, that's the person that's processing these applications, making sure that they're complete, making sure we have everything we need before we put it into review. Outside of just like volume, I mean, because volume can change. Sometimes, like we just sent out this stack of letters, like we may get a bunch in at the same time. Obviously, that could impact some of this timeline. But I would say within a couple of weeks, all the departmental reviews are complete, and a letter goes out that they need to apply, call and schedule for an inspection with the fire department and with the code inspector. From there, it depends on if we find violations when we go out. You know, a lot of times the inspectors are just trying to get things compliant. So I might go out and find a few things that are deficient and say, hey, call me back next week or in 2 weeks when this stuff is done and I'll come back. And then they'll do that and then I'll come back. So they don't, it might depend on how long, you know, that takes before they actually get their certificate. But in the meantime, we're not looking to close them. We're just trying to get the violation addressed.
No, I get that. I
So
just was
it's-
trying to figure
yeah,
out from the time it goes from licensing and coordinate department till it gets to you guys, like a timeline. So if someone was trying to open up a business or were they trying to change their certificate of usage from the time they apply to the time it gets to you guys, like it's probably about 4 to 6 week process at least, right?
And it could be
At
significantly
least, yeah,
less. I mean, it
yeah, I'd
depends.
push that out to a couple of months. And that's presuming that there's no major issues. If there's a zoning issue and they have to go get a special use permit or go through a different process for that, that's going to elongate the process because we're not going to be able to make a determination on the C of U until the zoning issue is resolved.
I mean, we're all aware that new business people, they don't know anything about this stuff. They come in and they hear that, and I understand it takes time, but if you're borrowing money and you're paying for that money, you can't open the doors of your place. That's what really costs. So
Or if you already
I think that key person is the person that initially takes that intake and says, you're gonna need all this, and I'll help you out to get some of the stuff. I mean, I know Marty worries about the one side. I worry about getting businesses started for
Yeah.
people who've never
Yeah.
done
And we
business
try
before.
to, you know, we try to give out as much info as we can and educate people. But let me give you a real scenario on what happens. Owner A has a commercial building that's either not zoned or not permitted to have a, let's just call it a corner store, for example. But he rents to a tenant anyway and starts collecting, you know, $3,000 a month. Says, go ahead and open. Tenant doesn't know what he's supposed to do. They come in and try to just get a C of U. They apply for a C of U and they're like, our office is like, time out. You don't have zoning approval to be a store here. You don't have a building permit to be a store. This was last legal as a church or an office. And then it all kind of starts spinning, right? And we can only help people if we're aware of the situation, but these owners are collecting thousands of dollars from these tenants and saying, yeah, go ahead. Or you know, I mean, you got to see some of these leases that we get our hands on. I haven't really got my
Like the
hands.
liquor store in Weston Gifford, maybe? You know, I mean, I know what you're talking about.
So it's like, if we don't know, I'm not sure how we try to help. I mean, we work with business development and MBD to try to get word out to this, but so all this kind of happens privately behind the scenes and we're not aware of it until a C of U application hits our door and we're like, well, hold on, you can't even have a store here.
So is there any way, like, so I didn't realize that it goes to the central office first before it comes to you guys. Is there any way,
Well, real quick, the permit office is a part of code enforcement. They're on the first floor, One Park Place. That is the kind of centralized location or storefront for customers to come in for these sorts of applications. So our licensing coordinator is right there. That's where phone calls would go. That's where they would come in person. That's where they would drop stuff off. But they are part of our staff. So the licensing coordinator is a employee of the Division of Code Enforcement. So we're all working together. Everybody else is up on the 7th floor, but this kind of one-stop shop for customers to stop in is on the first floor of One Park Place.
so I only say this because I'm not a code person. You know, we get calls and I'm like, listen, you gotta go through the process. Is there any way that at that front step, at the front, I call it the front door, right? Because that's the first initial to doing anything. that there's something that says, okay, this is the process, like, you know, like a little sticker. You're gonna have 4 to 6 weeks or maybe more, but meanwhile, make sure A, B, and C, because these are things needed to be,
Water, please.
in there, you know, look at what you're zoned at, look at this, because those are the things they're gonna, I mean, especially for new people, they would have no clue on
Yeah.
that. So then that'll help while they're waiting, right, to be thinking about that, or even the person at the front door, when they get the application, look into the address, because they can easily tell if it's
Yeah,
where it's zoned.
we provide all that information. I mean, we have computers right on our counter, but we also have a kiosk. It's like a giant TV with a computer on it that we assist people on. And now that zoning is a part of our division, we have representatives that will work directly with, you can have a permit person in front of you, the licensing person, and the zoning person trying to help you through this. But, you know, as I just stated, like in that scenario I kind of gave, like if that's happened numerous times, that takes a long time to kind of start things with zoning and apply for a site plan approval and a special use permit. Has to go to planning commission, it has to go to council, then you have to get a building permit, you have to get an architect, you know, you have to change it from an office to an assembly space under the building code. Then you got to get your, you know, it's just, there's a lot to it. And we do try to educate people on what this process is. And, you know, unfortunately, sometimes I think these tenants just, they don't know what they're supposed to have.
I would also add that our physical application for this EVU also identifies a lot of different licenses that they could potentially need, and it asks questions like, are you selling tobacco? If so, can you please attach a copy of your tobacco licenses to try to cut down on that? We also do that with zoning, liquor licenses, various sort of things that we're aware of and that we've tried to cut down on any issues later in the process for them.
Do we have a punitive measure against the landlord? I guess I'm asking that in a different way.
So when we issue violations for not having a C of U, the building owner is part of that and does receive that.
So is there a fine? Is it per day? What is the, I mean, do we need to strengthen that so that, because the business owner at that point, I see them as a victim sometimes too, where this building owner wants to rent and says, go ahead, start selling your, you know, soda and cigarettes.
So I think the violation for this is $100 per day in the code, but I'm not 100% on that. I think we could think about increasing that. It's not in the current amendments. I think we would have to either go to court to get that, and I'm not sure if courts would be willing to issue an order for much beyond $100 per day,
So
or we think about going through BAA.
Before we start
Two
increasing it, let me
options.
ask this, are we
Yeah.
enforcing what we have on the books already? Are we already going after these building owners? Do we get that money out of them when it happens?
So a lot of times, especially lately in the last year, we've been able to just get people to go through the process. Either that or they close entirely through one avenue or another. I mean, I think in the last year and a half, or even slightly less, there's been about 40 locations that have been closed under some sort of process, maybe not directly C of U. There, you know, there's been tobacco, there's cannabis, you know, there's state involvement, but these are commercial businesses. I think we're up to about 40 that have just shuttered because they were operating
Were mostly,
illegally.
were they leased premises from
all
the
of them.
landlord?
I mean,
All of them
mostly
were?
all of them are. I mean, very rarely do we find one that's the business proprietor and the building owner, which to your point is a problem. So we can take them to court, but a lot of times our remedy, especially in the last year and a half, is the business just closes and they,
What's to stop them from doing it again is my question. So if the owner, if we're just hitting the business owner, throwing them out, closing it, and that landlord still
yeah.
sits there with a piece of commercial property, they have no reason not to just do it again in a year.
well, it'll be a combination of either administrative fines through the BAA, like Rob mentioned, or going to court for that.
I think also our amendments, I'll have to double check, when it's in the review process, we've added a couple of provisions that would allow the division to look at the building's history and its compliance with the certificate of use. That wasn't in there before, so that's kind of a mechanism that we're trying to address that issue to make sure that we have a clear way to go after locations that are historically problems for these types of issues.
And vice versa, to your point, though, sometimes the building owner's doing everything that they're supposed to do. They have a proper lease, they've told the tenant what they need to do, and then the tenant isn't doing what they need. So then it's like, you know, also, we've seen it where the building owner is doing everything, and the tenant's the one that's kind of not doing their process, if that makes sense, kind of turning it around the other way. So I get your point. To answer the question, if we really felt like we needed to, we could issue administrative fines through the BA to the building owner, or take him to court. But usually, just stopping a business is enough to get them to work together because they're both kind of being impacted that way, or they should be.
Some repeat offenders, because if you, I mean, I just think logically speaking, if you, and I can think of one store, I won't pick on the corner, but if the inside is set up to look like a corner store and we get rid of one business, throw them out, the inside is still set up to look like a corner store. If I'm a landlord getting $3,000 a month, guess who I'm gonna look for? Corner store guy, unless you hit me with $3,000 a month in fines the last 6 months. That might stop me.
Yeah, I mean, I think we could look into that. I think the issue will be finding a way to enforce that either through courts or through a BA systems to make it to the point where they're actually going to send us the check for that. That would be the biggest
Well,
one.
even if we don't get the check, make it hard enough on them that they don't do it again. I mean, that's.
But if we get a store closed though, technically it's no longer in violation, so it kind of, the enforcement process where we would escalate that to go to court kind of stops or pauses because it's like, well, they're not open anymore, so, but I get your point. And we are trying to do a lot, and we have done a lot to improve this. As Rob noted, we've done a lot of work with Corp Counsel to make this kind of a seamless process that protects us from, defending lawsuits if that's the case. Because we've been challenged numerous times, and we've been giving people, due process, but also being aggressive, making sure that they're following the laws and procedures on the books and protecting our neighborhoods.
Jake, I have a quick question. So, going back to what Councilor Cole was talking about, the first part of the process. A lot of the people that are trying to put their businesses together, they don't know how much does it cost to get to that certificate, because I'm sure we have a fee, and then there's the architects, and then there are forms that need to be completed that are not generally friendly, not because the questions are not friendly, but because they're hard to answer. So you need to get then professional help to do that. So is there any way, going back to her comments, that we can alert, our residents that want to do business to how much this costs?
Maybe not necessarily a estimate in cost, but what we can do is I just wrote a note down before you said that.
Things that will cost money.
Yeah, we can try to come up with some resources to put online and have in person at the permit desk. We can work with our PIO and business development under Eric Ennis and his team because they're well versed on trying to help people get through that process or telling people what they need before I'm even aware of it. One of the business planners has already spoken to somebody many times, but it's the ones where we're not sure, where nobody knows it's happening, and they just come on our door and they're like, "I'm here to give my CAVU, like here it is," and we're like, "This isn't legal to have a store here yet." Those are the tough ones, but at least we can have resources online and try to direct as many people as possible. So I'll work on that, and there are some resources under business development already. It's just getting it in front of everybody that needs it.
That would be great. And also, I had another question. When through the process, when they come to the sites to do the inspections and they find things that need to be addressed, they give them a certain amount of time to address those before they open and they get the certificate. And I have been working with a couple of the businesses actually in Geddes that they pointed out the things that needed to get done, they did it, then they called to have people come back, but nothing. And the next thing we saw was a letter saying that things were not addressed and they were fining them. So of course, we just made a phone call and we explained. So everything is okay, but that's because, I got in the middle,
So code enforcement has 6 building inspectors dedicated to doing commercial periodic inspections like certificate of use. And the fire marshal, or the fire prevention unit under Chief Craner and Captain Wilcox has a team of fire marshal inspectors as well. I mean, typically we can get somebody out within a couple of days. So I could look at that one. If you want to give me the address offline, I can kind of.
it's been resolved. It's okay.
Yeah.
I was just pointing it out.
That shouldn't happen. It really should only take, a few days to get somebody back out.
As soon as we found somebody, it was immediately resolved.
Okay.
And actually, the team, I've been there a lot with some of our residents that are, getting their businesses together, and your team has been phenomenal.
Yeah.
From Christian to all of the others, it's a very good team.
And we have a staff of 5 people that answer the phone calls for scheduling of that. So really, your phone call should get through. They've got everybody's Outlook calendar and availability, and they'll schedule you when the fire inspector and the codes inspector is available.
Okay.
They all
I
meet,
wanted
I
to-
mean, the oh, I'm sorry. Jordan, did you want to say, go on, Counselor.
I wanted to ask about 173, the procedure for background checks. One, do business owners or tenants know that they are going through a background check? Is that on any of the documentation?
I would have to check on the application if there's been notification on that. I'm not sure offhand.
And how often are people being denied due to a background check? So that would go to 169, to speak to 169 as well.
Yeah, it doesn't happen much. I can think of like 2 off the top of my head in the last like bunch of years. It's really what they're looking for, not to speak for the police department and Sergeant Romaine, but I believe it's if they've had a felony in the last 5 years.
The exact things they look for is in the.
So this doesn't state the last 5 years, I don't believe. Oh, yes. And
I think it's
felony,
5 years for a felony,
proceeding
it's
to
2
the-
years for
okay,
misdemeanor.
yeah.
With specific things listed, and if there's something that's not listed that comes up, that's not reported to the division by SPD, is my understanding of it.
So
And I can only think of
my-
2
You only
in
know
my
2?
whole time, where that's been.
But my concern is that, not to do that at all, but more or less, I guess the 5 years is a good cushion. But what about businesses that are open and then they're violating some of these, laws?
So when they have to renew every 2 years and it's checked, or rechecked, I should say.
Yeah, and so I guess if the question is like if they're violating laws, like if we become aware they're selling spike or other illegal drugs, that's something that we would probably work with the division to maybe bring a petition in court to try to enjoin that activity. We wouldn't wait until a renewal if we were aware of unlawful activity. But it wouldn't necessarily run through this exact section of the code.
All right, and, for the 169, can you just give like some specific reasons why what would be like some of the causes for denials of an application?
So 169, this is the procedure for hearing following denial of certificate of use applications. Is that just want to make sure we're on there correct?
Yeah.
Okay. So when that happens, so this is triggered when the division has denied an application. When that happens, they send a notice to both the business owner and the property owner, and that notice will identify all the reasons which it was denied. Most of the reasons, if not all the reasons for denying, are listed in the code at 27168. So that notice would, it's a little table and it says, zoning or division and licensing, and it gives a brief description of what the problem is. Following that table, there's a few paragraphs explaining that under this code that an administrative hearing has been scheduled. It gives them the time and place of the hearing, explains to them that they'll have a chance to address the denial reasons. They can, under our amendment, they can call the division to have that rescheduled if the time doesn't work. And that's what the notice would look like. Following that, there would be a hearing with a hearing officer from the division who would listen to whatever issues the business owner raised.
So this isn't like CPC, this is through your department?
See,
Yes, yeah, this is a review by like the Division of Code Enforcement or the departmental review, like police, zoning. Yeah, it's not through a board.
Okay.
And I'll say a lot of times, they're really more of a hold. I mean, it technically is a denial, but it's like, I need to deny this right now because I can't even give this to you because you need a special use permit first. Or you need to get a building permit to change this from an office space to a restaurant first before you get your operate. So technically we are denying those, but it's really more of a, hey, we're pausing this because you can't get this yet. You need to go get these other things, then come back and get this. Most of the time people, as long as they can meet those requirements, they can get through the process. I guess there are some instances where taxes might be an issue or water billing, but you know, we've worked with business proprietors in those situations because that's really more of a building owner thing. And those are things that Ryan and I have worked hard on to try to, you know, make sure we're not impacting a good business proprietor.
And then if they seek the special use permit after that denial, that's through the CPC.
That is, and then that
Or zoning.
comes to you, and that kind of establishes the land use. Then if they need any building permits, they need to get that, and then the CAVU can be applied for with other licenses like tobacco or liquor or entertainment or whatever the case may be, depending on the business.
So, Jake, just have a question. This right here really, these changes are only really affecting businesses, right? You didn't have any changes for any other things that were going on in code as far as,
Yeah, this is specific to
Certificate of
business
occupancy.
certificate of use only, which is only for, yeah, certain commercial establishments and business.
do you have anything coming through with any other changes through your department, like the certificate of occupancy or any of those things coming through?
So for the Syracuse Property Conservation Code, is that what you're asking? We've talked about doing some adjustments to Ronald Registry, but we don't have anything that's
Okay,
imminent.
so this is just the only changes right now as far as,
Yeah, only for certificate of use, that's it.
okay.
So like, once again, back to procedure. At the end, police and the fire department, how's that work? What departments check in first? You determine they need a certificate of use, and then they're all checked through, and the last ones are the uniform bureaus or what? Police and fire?
No, they're one of the initial, police is one of the initial reviewers after
Fire's at the
the
end,
application. Fire and codes are doing the inspection. Once they sign off on the inspection and everything's, else has been approved, certificates issued and generated by the inspectors.
Because there has been incidences where the fire department comes into some place and determines the way they got things set up, it's not gonna work, and they say you can't open up, right? They change, is that a change in plans that they aren't aware of? Or I'm just wondering, at the last minute, it's not the best way to manage resources.
The inspection is the code that we're addressing or using on those inspections is property maintenance and fire code. So these are things that always have to be up to,
Right.
you know, maintained. You know, I'm not speaking for the fire department, but I think sometimes they find that people are, you know, deep frying food and they don't have a commercial kitchen hood above it, which is dangerous. So it's like,
That should have been determined way before in the plans, right? I mean, in the plans, it would have been you would have seen.
well, not necessarily, because a location could have been a restaurant that didn't do cooking like that. A new person moves in, and we don't know that they're doing deep frying food, and we come in for the inspection, we're like, where'd this, you know, French fryer come from? You're not supposed to have, you know.
Hopefully, you would have.
You know what I
caught it
mean?
Before they started cooking.
Yeah, but that's an example of how we might not even know that they put that in there. It wouldn't be on a setup. You know what I mean? Does that make
sure.
sense? And maybe that's a bad example. I'm just trying to give a scenario
I'm
of
just-
like when that happens, like
I
the
think-
fire department's not the bad guy. They're trying to prevent
Oh,
fires.
I'm not, I know, but I think sometimes, and they got their jobs, and I think, I think as far as your primary responsibility is codes, I think sometimes with them engulfed in that,
Yeah.
they treat it like it's, I'll get to it when I get to it.
If it's a new establishment that is going through permitting, all that stuff for suppression and kitchen hood and sprinkler and fire alarm should all be done before a CAVU is even,
even
yeah.
contemplated.
But if it's an existing building, existing location, and, there's a new CAVU, and we don't know about alterations to a kitchen or something like that, that's how maybe that might happen.
Okay.
And then the Onondaga Health Department steps in. The Onondaga Health Department, also they
Yeah, I mean, the health department's out doing inspections for, county plumbing too, depending on, they're requiring like grease traps.
Exactly.
They have their own.
I want French fries.
Yeah, right.
Like I know when we go to make a owner or tenant aware that they're conducting business without permits or use certificates, and you, what is it called? Placard?
When we like declare something
Put the thing
unfit.
on the door.
Yeah. You
Okay.
mean the permit placard that says
Yeah.
permit in red? Yeah.
Yeah, okay. So say we know that a business has moved out, this location has been vacant for 3 months or more. Could we come up with a sort of placard to put on a door or so to notify anyone who might be potentially looking at this space that these are the next steps you need to do to operate a business here? At least first steps. So that people then aren't saying, well, I had no idea that I was supposed to do this.
I think we could think about that. Initially, there are some legal restrictions on when we can, like, post a placard on a building, so we'd have to, look at that more closely, but I think it's something we could at least look into.
Not to get it too technical, but the fire code does have very specifics about some of that, and we would just have to do, I like the idea, because then it's like, oh, I'm gonna call, there might be a for rent sign, right? And then maybe
Yeah.
right next to that, there's a sign that says, before you lease this space, like,
Yes.
you need to check with City of Syracuse zoning and licensing and permit, or something along those lines. Maybe we can do something like that. We can do some research on it.
I mean, I guess it kind of mimics, like, if I'm purchasing a property in a historic neighborhood, the realtor selling is supposed to make the buyer aware that this is a historic
Sure
neighborhood.
they do.
Yeah, they do. So, supposed to. So I'm just saying, like, something to that effect, like, get ahead of it.
Yeah.
I didn't mean to I just try to make this smoother for like the new business people, because they don't know any of this stuff. And that's why I really think you should be allowed to have on your, whatever your say is, Jake, a conditional license. Sometimes I've run into things in the past where businesses, all of a sudden they run into a stumbling block like that. They don't know that they needed that. It was determined late. And so, I think that conditional, I think you should keep that in there.
Especially when we have out-of-town investors who are purchasing properties, but then renting it wherever they live. Their zoning or permitting may be completely different from ours, and they have no idea what our city laws are. So I think,
Also to that point, the same way that first-time home buyers take a course, there are plenty of courses around in all languages, that maybe if you had a list you can tell people to go to get informed.
Yeah,
I can provide that list.
okay.
I'm just wondering if maybe it could also be some type of partnership information sharing with county for when they record deeds, for when a new owner purchases. Basically, they are given the information that next steps.
Okay, any other questions? I'd like to see remove the reference to, I'd like to be able to have Jake give conditional certificates of use, if that's okay with you guys.
Yeah,
It's just right here, section 27-164, the second bullet point.
yeah,
Yes. C of U, none of this would really impact anything coming to council directly. If somebody does require a special use permit, then that goes through the process as is today.
Please.
So a C of U denial or closure would go through a hearing process that would not involve, it'd be administrative hearing. It would not involve council or planning commission.
Correct.
No, those were special use permits, which,
Yeah, that's a separate, I don't think anything in the certificate of use runs through the common council for anything we need to do. Previously, I think the revocation process did have some common council involvement. I think we took that out and went straight through the division on that. And as far as the conditional certificates of use, we have started sending out like reminder letters to all the businesses we're aware of in the city now, reminding them that they need this certificate of use and that would they please apply. And eventually, we remind them eventually down the road there'd be citations, but no active citations right now.
as far as 174, the 27-174, the fees, the fees are not refundable, what does the fee look like? Is it, it's just a standard fee, like $45 or $60? It's not like based on the
It's standardized. I think it's $500.
$500?
$500, yep.
Is not refundable.
Not refundable.
And that $500 is for what? Just the license, the certificate?
Yeah,
usage?
so the kind of backbone of certificate of use and licensing is really under the charter and under the commissioner of finance, and then actually policed by the chief of police. Like, Division of Code Enforcement kind of took that over maybe in, oh, Ryan, what do you think? Like late 2000s, like 2008, 7 range, maybe before then, where code enforcement kind of took over that process. Like even the licensing coordinator used to kind of live under finance, but we moved them into the permit office, put them onto my budget. Like, so there's been some structural changes, but a lot of it really, if you dig into the ordinances and the charter, it's really under Commissioner of Finance.
But to the point we were making before, that's the kind of thing you need to put in that list of how much it's gonna cost you.
Yeah,
To go
I
through this
mean,
process.
this has
That should
been
be
the
like
fee.
at the top.
It's been the fee as long as I can remember, so 20 plus years, maybe even longer. I don't know the origin of deciding that amount.
No, I'm not questioning the amount. I'm just saying that should just be notified. Like, people should know that from the beginning, like, there's 500 feet for this, and if you're gonna put a sign, there's another fee, and there's like, so that they know sort of ahead of time, instead of when you know, it's like
So that you're prepared.
purchasing a house, and then all of a sudden, they're like, oh, on a closing cost, you got A, B, and C. Somebody hopefully is coaching them before time.
So that fee is due when I bring my application back for a certificate of use.
Yeah.
For the application to be processed, you need to make payment.
If somebody wants to talk.
I have two
Introduce yourself.
businesses, and I do not recall ever paying $500.
I do.
Hi, I'm Heather Davis, also from Corporation Counsel. I worked with Rob on drafting the amendments. Just with respect to the fee, I will say Jake and Rob internally Jake and Ryan have internally decided that people pay that fee. And again, we didn't amend the fee. It has been the same for a very long time, and we made the decision not to increase it more. But with respect to them paying that fee, we aren't, if they are denied, asking them to necessarily repay the fee when they come back. So if they have already paid the fee and they were denied for any number of reasons, say a zoning reason, we denied them, but then they take care of the zoning reason and they come back to get their certificate, they might have to update their application, but it's been in Jake and Ryan's discretion not to make them repay the fee. So it's not that they have to pay every time if they are denied. I did just want to clarify that it is a lot, but it's not every single time if they are denied.
Yeah, and our staff does a good job of like, hey, we're not even gonna take this from you right now. You need to go do like 1, 2, 3. Like, we're not looking to just grab somebody's check and their application, knowing like that they're gonna fail or can't. Like if somebody let's say somebody applied for a C of U in City Hall. It's like, I can't give you a C of U to operate in City Hall. Like, it's a government building. Like, you know what I mean? Like, we would never even take that from them and process it. So like, very rarely, I don't even, Ryan,
So I
can you think of
guess-
an instance where we've taken money and we haven't been able to get somebody through the process? Like where it's like, I want my 500 because I never even opened it. I don't
Oh, it's a
even.
guarantee?
So I
Not,
guess-
it's not a guarantee, but like, I just don't know that it's happened where we've received an application and a check and then, you know, where it's just totally failed, like entirely.
So I guess for me, I'm just trying to think of myself. Because like I said, I didn't never pay this. But, so I'm thinking if I have a salon and I'm going to a previously existing salon, I'm just moving my business to a new place that already had a certificate of use. So am I then paying $500 to get my own certificate of use when it was already, or is it just being transferred to me?
So
Which I think
a
we already
salon
discussed
wouldn't
that.
need one. Like, this is just for like bars, restaurants, smoking establishments, corner stores,
okay,
gas
maybe
stations.
that's why.
So yeah, there's certain businesses that
So
are
I was
exempt from
like,
this.
I
It
never-
only covers certain ones. So, but like, to your point, if you owned a bar and had one and I buy your bar and I move in, yeah, I've got to get my own.
Okay.
I'm guaranteed I didn't have one of them over there. I know for sure. But that was in 1970s, so, okay.
Okay.
Thanks, Jake, Rob. I am Miss Davis and Ryan. You definitely have a real difficult job, and thanks for trying to explain this to my colleagues here, but I'm sure you'll hear more from us in the future. So I'll have a motion to adjourn.
So moved.
Someone-
Second.